to our special committee meeting. Welcome the IEC.
Recording in progress.
Parliamentary Legal Service, the State Law Advice, and the Department of Home Affairs will stand on the decision of the last committee meeting that we have approved both the A list and the IEC presentation. The State Law Advisor had to consolidate into A list for purpose of adoption formally, and then we'll give to the Parliamentary Legal Service if they want to raise the issues that they want to raise, and then we stand off the meeting. So that is a process which yourself as the team have then agreed on how we're going to deal with today's meeting. If there's any other matter, the legal service will highlight. But I think we're comfortable with how we've considered the two reports. I will venture into the second item. If there's an apology, Mr. Matonsi, to render.
Yes, Chairperson, there is an apology from Ms. Mlekwa. She said she might be joining late. I hope when she joins, then it will not be done with the meeting. And then there's also an apology from the Minister and the Deputy Minister. That's all, Chairperson.
Okay, thank you. Can I check if there's an apology from the IEC?
Good afternoon, Chairperson. It's Mosotu Moepia. I would ask that I don't use the video because of signal where I am at. We are fully represented. The apologies were rendered on Monday. The same apologies really. Sorry, on Tuesday. The same apologies we have, but we are fully represented. Thank you.
Okay, thank you very much, Commissioner Moepia. The State Law Advisor, Ms. Govender.
Good morning, Chairperson.
Good afternoon.
Sorry, good afternoon, Chairperson. It's Raya Williams here from the Office of the Chief State Law Advisor. I'm accompanied by Ms. Sarah Govender. Ms. Sarah Govender and by Ms. Aisha Johar.
Okay, thank you very much. Parliamentary Legal Service. Telana.
Good morning, Chairperson. I'm not. Oh, Mr. Njikela is here.
Yes, good afternoon, Mr. Njikela and Telana.
Good afternoon, Chairperson. I'm here with Telana. We will be supporting the team.
Okay.
Thank you very much.
Thanks. All apologies noted. We'll then invite the State Law Advisor to present the issues which were agreed in the last meeting. Thank you.
Thank you, Chairperson. Good afternoon, Chairperson. Good afternoon, honorable members. Good afternoon, commissioners. We have collectively, together with the IC and the Parliamentary Law Advisors, we have met after the last meeting on Tuesday, and we've considered the proposals of the IC as per the committee's instructions, and we've incorporated their proposals in the bill, Chair. Okay. After we've incorporated the proposals in the bill, we've shared the drafts with the Parliamentary Law Advisors as well as the IC and the department, and they were in agreement with the proposed changes. Thanks, Chair. If I may proceed. The first change we made was the insertion of the definition of person, which means a natural person. Okay. The next one is on page 3, Eddie. Yeah, clause 2, that's insertion of a new clause. On page 3, from line 14 to line 17, to omit paragraph CA and to substitute the following. A declaration signed by the duly authorized representative of the party confirming that each candidate appearing on the party's provincial list of candidates referred to in Schedule 1A is registered to vote within the province in which the election takes place. That accommodates the proposal made by the IEC. Okay. And then we move to the next one. The next one is an insertion of an amendment to a new clause, and that would be the new clause 5 in the bill. It would read as follows: on page 3, after line 28, to insert the following new clause after clause 3, and to renumber the subsequent clauses accordingly. As you'd note, there's a few new clauses which has been inserted in the bill, and therefore all the subsequent clauses as contained in the bill will be renumbered. Okay. And then the other one would be the amendment to clause 4 of the bill. When we do clause 4 of the bill, this indicates the clause 4 of the current bill as introduced in Parliament. When we have the B bill, it will reflect the new numbering. But for the purpose of the A list, we still refer to the clause as is contained in the bill as introduced, even though we introduce or insert new clauses before these clauses. So for the A list, the numbering still corresponds with the bill as introduced. Okay. So we look at clause 4 of the bill. Paragraph, section 31, capital A, subsection 1, paragraph B. The following further down. Yeah, thank you. For the provincial legislature in a province in which they are registered as a voter, and then the proviso be equal to all would be provided that the dependent candidate may only be eligible to be a member of either the National Assembly or a provincial legislature. Okay. The next amendment would be on page 4 of the bill to omit lines 6 to 9 and to substitute with the following. Paragraph A would now read as follows: a completed prescribed form confirming that the candidate has submitted in the prescribed manner the names, identity numbers, and signatures of voters whose names appear on the segment of the voter's roll for that region or province in which the candidate is standing for election, and who support his or her candidature, totaling at least 30% of the quota for a seat that was required for a seat in the previous comparable election. That's a drafting as proposed by the IEC. The following would be item number 5, yeah, on page 4, to omit from line 17 to 20 and to substitute with the following. So paragraph E will now read as follows: if contesting an election of a provincial legislature, a prescribed declaration signed by the candidate confirming that he or she is registered to vote within the province in which he or she intends contesting. Okay. The next one would be on page 6. There we omit on page 4 in line 37 of the bill, we omit the reference to paragraph A, as well as in line 43 on page 4, we omit the reference to paragraph A. And that's per the IC's proposal as well. The next one is page 7. Thank you. The words preceding paragraph A will now read as follows. Section 58, subsection 1, every registered party or independent candidate contesting an election may appoint such agents as may be prescribed for each voting station and for each venue where the proceedings provided for in part 3 or 5 of chapter 4 takes place. That's when we provide for the number of agents should be prescribed, and we don't insert a minimum in the act, okay? The next amendment is on page 18. To see, yeah, 2C is an insertion. Where an independent candidate is contesting where an independent candidate is contesting in more than one region, the votes received across regions for that independent candidate may not be aggregated in order to obtain a seat in the National Assembly. Okay, that was taken into account Honorable Pilay's proposal. And then on page 19, after independent, we inserted the word candidate to have consistency with the bill. Independent candidates are referred to as independent candidate in the singular. And then further down, paragraph D is the same thing. And then in paragraph E, it was just a correction. It was seat instead of seats. So we changed it to the singular. Thank you. And then the next one on page 20, 4B, at the bottom, we've made the addition as proposed by the IC. So paragraph B would now read, an amended quota of votes per seat must be determined by dividing the total number of votes cast nationally on both the regional and compensatory ballots minus the number of votes cast nationally on both the regional and compensatory ballots in favor of the party referred to in paragraph A by the number of seats in the National Assembly, plus 1 minus the number of seats finally allocated to the said party in terms of paragraph A, minus the aggregate of seats won by the independent candidates. Okay. The next one is on page 21. We've corrected number of voters to read number of votes. And then page 22, we've inserted the word the changes. A grammatical correction, page 22. Yeah. Page 26, the same with the changes required by the context. Yeah, it's a more simpler way of using the Latin terminology mutatis mutandis. So we say with the necessary changes required by the context. Okay. And then the next one would be on page 30, item 23.1. Okay. We've made the existing 23 sub 1 because we've inserted a sub 2. Okay. Sub 2 now reads, if additional seats remain after the allocation in sub item 1, a recalculation must be done as follows. A, disregarding the votes and seat allocated to the party or independent candidate contemplated in sub item 1. B, disregarding the votes and seats allocated to independent candidate already in office, and C, recalculating the result for the region or provincial legislature in terms of the provisions in terms of item 7 or item 12 respectively. Okay. And then the long title comes in at the end. This long title would substitute the long title in the bill and not the long title in the act. So the long title basically reflects all the changes made to the bill. So with the long title, we've adjusted it accordingly to cater for the clauses that was omitted and the expressions in the headings to some of the sections which was omitted. The long title would read as follows. To amend the Electoral Act 1998 so as to insert certain definitions consequential to the expansion of this act to include independent candidates as contestants to elections in the National Assembly and provincial legislatures, to provide that registered parties must submit a declaration confirming that all its candidates are registered to vote in the province where an election will take place, to provide for the nomination of independent candidates to contest elections in the National Assembly or provincial legislatures, to provide for the requirements which must be met by persons who wish to be registered as independent candidates, to provide for the inspection of copies of lists of independent candidates and accompanying documents, to provide for objections to independent candidates, to provide for the inclusion of a list of independent candidates entitled to contest elections, to provide that independent candidates are bound by the Electoral Code of Conduct, to provide for the return of a deposit to independent candidates in certain circumstances, to amend Schedule 1, to substitute Schedule 1A, and to provide for matters connected therewith. Thank you, Chairperson. Those are all the changes made to the A list subsequent to our meeting of the 22nd of August.
Thank you very much. I will invite members to move for the adoption of the minutes, of the A list, noting that we've considered it. If there's any matter members will raise, but I'll start with the, and then I'll invite Mr. Njikela and the team. Unless Mr. Njikela, you'll want to come in now before members come in. Can I get that indication? Telana?
Chairperson,
okay, Mr.
I will be subject to your direction. There is a point that we would wish to make in as far as the way forward. Maybe I should hold back until the members have deliberated on the A list, because what I seek to address, Chairperson, relates to procedure. After having the committee made a decision on the proposals, so maybe I should wait until after the members have made a decision on the proposals.
Okay.
All right, Chair.
No, thanks, members. This is the consolidated A list, which you have already considered. Can I invite Honorable Play, Honorable Tito, Honorable Ross, Honorable Kanyile, Honorable Mohale, Honorable Lokwase, Honorable Ramlobe, and Honorable Molekwa and Honorable Mutise. In that order.
Thank you very much, Chairperson, and good day to all honorable members, colleagues, stakeholders that are present. Chair, I think that I must first start off by appreciating both the teams for having gone back and being able to finalize on the matter. And I think it's quite a historic moment for the committee itself. Chairperson, I move for the adoption of the A list, having deliberated over months on end and having looked at all of the necessary items, clauses, etc. I am quite confident that we have exhausted this matter, Chair. And to this end, I want to support that the A list is adopted and that we move with the procedure. Thank you.
Mover for adoption has been carried. Honorable Tito.
Thanks, Chair. Greeting to my colleagues and everyone who is present. Chair, I would like I would like to ask a question on, I think that is on number 4, because of, I think that the advisors, they didn't give us a clarity on that one of being specific. Who is the representations by interesting parties in that format where they're saying that the commission must determine a fixed number of seats reserved for each region for every election of the National Assembly, taking into account available scientifically based data in respect of voters and representations by interested parties. Can they just be specific? Who are the interested parties? Thanks, Chair.
Okay, thank you, Honorable Tito. Honorable Ross.
Thank you, Chairperson. Chairperson, I've stated over recent times and over recent meetings the DA's objections to certain of the clauses and proposed amendments. And therefore, unfortunately, we are unable to support the proposal to adopt the A list.
Okay, noted. Honorable Kanyele, I think that also will be a Honorable Kanyele.
Chairperson, I don't think she's in the meeting.
Okay, sorry. I'm just working on the Honorable Lizelle. She was trying with the network earlier on.
She's also not in the meeting, Chair.
Okay, Honorable Mokhale.
Unless if you use another device, it's not in the meeting.
Okay, Honorable Khosa.
Thank you, Chairperson. Chairperson, let me appreciate that's been done by the two teams, especially after we requested them in and make an A list for us to adopt today. And Chairperson, without any waste of time, I would like to second the adoption of the A list. Thank you.
Thank you, Honorable Ramolobe. Honorable Molekwa. She's not in the meeting, no?
Yes.
Okay, Honorable Modise, Msa.
Thank you, Chair. Let me support and second the adoption of the A list as it has been amended from the meeting we had where we requested some of the items to be amended or added. So I support the adoption of the A list as it is. Thank you, Chair.
Okay, can I check Honorable Lizelle if you have joined?
No, she hasn't joined, Chairperson.
Okay. There's a question which is raised to the IEC. I think they will deal with that. But I know that this question has been labored in many times in our deliberations of the committee, and a decision were taken around that. I will not suppress that IEC may not answer Honorable Tito. I will then outline the process then when after the IEC has made an impression on the response, and invite Mr. Njikela. I think, members, if you recall well, all of us, we considered the deliberation arise from the A list in our last meeting. And sufficiently supported that. I'm just trying to recap to the meeting. Mr. Miepta, I'm not sure if you can delegate on the matter. Then we move to Mr. Njikela.
Thank you, Chair. As you correctly pointed out, we have dealt with the matter even on Tuesday. I am going to ask the CEO to deal with the matter again so that there is clarity where there wasn't at all. CEO, would you kindly deal with the question raised by Honorable Tito? Thank you.
Thank you, Dr. Mabja, and thank you, Chairperson, and Dr. Chabane. That item 4 relates to the distribution of the 200 seats for the 9 regions. The Commission ought to take into account the registration of voters, in other words, figures from the voters' roll, as well as invite public comment from interested parties. You'll recall that policy making within the state apparatus has got to follow the invitation of public commentary. So that interested parties merely means publishing your intention, inviting people to comment on the matter, and then making a final determination. It is part of the public participation impulse that is inherent within our constitutional architecture. Thank you, Chair.
Thank you. That offer the response to the issues that were raised by Honorable Tito. The bill has been seconded. I'm sorry, the A list has been seconded as a reflection of the deliberations. Honorable Ross is objected to the A list. Honorable Tito has not given any indication. Can I come back to Honorable Tito?
Yes, Chair. Thanks, Chair. Yes, I'm also objecting. We are also objecting as the EFF. Thanks, Chair.
Noted. The A list is carried with those objection noted, and it's resolved as such. I must further write that in our last meeting, all members considered the A list as a true reflection of the deliberation which were carried during the recess period. And I think that is a matter we must note. I'm going to invite Honorable Mr. Njikela to raise issues of procedure from here on. How we're going to move forward if there are any other issues that the committee need to consider. Thank you, Mr. Njikela.
Thank you very much, Chairperson. I have one issue that I think I should raise with the committee. I don't know if I'm audible, Chair.
Yes, you're audible.
Chair, I have one issue which we had raised in our first presentation. And the issue relates to the matter of the extent of the amendments that we may have effected following the process that the committee has undertaken up to now. We had raised the issue, Chairperson, earlier on that depending on the extent of the amendments that the committee makes on the bill, we may have to consider two issues. One issue relates to Section 59 of the Constitution, which obligates us as Parliament to facilitate public participation. And the second issue, Chairperson, relates to Rule 286 of the NA rules, which speaks to the issue of the permission to broaden the scope of a bill. And these, Chairperson, I must say right at the beginning, they call for value judgment on the part of the committee. Let's start with Section 59. Section 59 obliges Parliament in its lawmaking process to facilitate public involvement and public engagement. And Chairperson, we have done a very thorough process up to now to engage the public. There were public hearings, there were invitations for public submissions. All of those were considered. The only difference could be this one, Chairperson, is that we may have effected amendments that the public at the time may not have had an opportunity to engage with. And this is the uncomfortable part. We have looked at the South African Veterinarian Association judgment, which was delivered, I think, in 2018. And it deals with this issue. Some of the members may remember that only one amendment was made in respect of that bill. It was to insert veterinarians in the context of the medicine-related amendment bill. And the Constitutional Court, having considered the entirety of the process and the amendment, set a test for Parliament, and the test was the materiality test. To what extent have you made material changes or substantive changes to the bill? That may require the public again to give comment on the changes that you are proposing. And I think that's where we are, Chairperson, now, where we have to reflect on all the changes that we have now accepted as the, in as far as this bill is concerned. Are these changes material? Are these changes substantive to justify us going back, firstly, to seek permission of the National Assembly, to the extent that we may have broadened the scope of the bill that was initially introduced by the executive. And I need to emphasize this position. This is an executive bill, Chairperson. It was introduced by the executive. In the amendments that we have adopted now, it is possible that we may have broadened the scope of that. And I can give you specific examples of the extent to which we may have done that. For instance, there was a cooling off period, which now the committee has agreed to completely remove. Is that a substantive amendment? How material it is to what the members of the public have already commented on. There is a new proposal of multiple regions for the ICs, that is the independent candidates. It was not initially there. It has now been proposed as the new position that they should be allowed to contest in multiple regions. How material and substantive that is, assessed against the SAVA judgment that I've just referred to. So this is the assessment, Chairperson, that we need to make now in terms of whether we need to go to the National Assembly to seek permission to broaden the bill. And I'm sure my colleagues may add on a number of other provisions that we have amended. I'm just picking up on these two to just demonstrate that there may have been a shift from what was introduced, and we may have broadened the scope of the bill, which may invoke Rule 286, which specifically says if the committee intends to broaden the bill or effect amendments that broaden the scope of the bill that was introduced, the permission of the National Assembly must be sought and granted. And I think that's where we are, Chairperson, now, assessing all of those amendments that we have made and the materiality of those amendments. Do they give effect to what is set out in Section 59 of the Constitution? And I want to go back to the SAVA judgment. SAVA judgment dealt with the issue of how do we deal with the issue of dispensation of medication. The veterinarians were not included in that, but the committee PC on health decided to include them. And they inserted just one word, which was veterinarians. And there was a big fight about it, whether after having made that decision, they should have gone back to the public. And the Constitutional Court, having considered the entire process, made a decision that because it is an entirely new provision, Parliament should have gone back to the public, re-advertise, allow the public to comment on that, and then made a decision. So to the extent that it failed to do so, that provision was found to have been invalid and unconstitutional for lack of public participation in terms of Section 59. Now, it has been suggested in some circles that this can be perhaps deferred to the NCOP. Now, the Constitution is very clear that Parliament is composed of two houses. Each house has its place to play depending on the classification or tagging of a bill. The bill we are dealing with here, Chairperson, has been tagged as a Section 75. And the implication is that it is not a bill that significantly or substantially affects the province. It is a bill that it is an ordinary bill. So that responsibility cannot be shifted from the National Assembly to the NCOP. These are the processes that must be happening within the National Assembly. What Chairperson would like to put on the table for consideration by the committee is that given the amendments that we have just adopted now, that it may be appropriate for the committee to make a decision to advertise the new amendments. It may be for a shortened period. It doesn't have to be a full period. It doesn't have to be public hearings that must be done. Written submissions may be sufficient, but for the public to engage with the changes that have been made to a bill which we all already know now is a matter of great public interest. And we have seen from the submissions that have been made, from the public hearings that have been done, that it's a matter that affects a majority of members of the public. Publish it for a limited time, allow for members of the public to make submissions on the amendments, not on the entire bill. Then the committee can engage with those. And I'm saying this, Chairperson, fully aware of the pressure of time that we had to go back to the Constitutional Court to seek an extension for us to be able to do a thorough job on the bill. But short-circuiting the process is not the solution either, because we may end up jeopardizing the election that is forthcoming in 2024. So, Chairperson, I'm just putting this issue on the table. And of course, the committee is entitled, as I've said, to assess the materiality of the changes that it is proposing and the substantive nature of those proposals. But at the back of my mind, I suspect that some substantive amendments have been made to the bill, which may justify us giving the public another bite at it, even for a shortened period and on written submissions, and then the committee may make a consideration on that and make a decision, and the process goes forward. Chairperson, through you, I would like to invite my colleague, Telana if there is anything that I may have missed in my that she may, if there were any gaps that she may want to fill in there. Thank you, Chairperson.
Thank you, Chairperson. Through you, I don't have anything further to add, but if the Chairperson will allow, I can just point out a few of the sections that may require permission from the House, and those are new sections as per Mr. Njikela pointed out. Rule 2864C does say that where you have proposed amendments to other provisions of the legislation, you would need to seek permission. And those include the adding of new definitions such as person, the new amendment to party liaison committee, which is now party, which is political liaison committee. And then the deletion of section 36 of the Electoral Act, which was the section dealing with candidate nominations that do not comply with section 27. And then also the amendments to section 20, 39(1)(b), 58, 59, 62, 64, 66. These were all amendments to where it dealt with agents and political liaison committees. And then also the amendment to section 96(2)(c), which was the forfeiture of deposits. These are all new amendments that weren't in the original bill. And that's all, Chairperson. Thank you.
Thank you. Do I have to invite State Advisor, Ms. Williams?
Thank you, Chairperson. We have nothing further to add at this stage.
I think thanks, Mr. Njikela and your team on the last point. Earlier on during the, we did raise that caution. Mr. Salmon did raise in his presentations when we're dealing with the, we'll note that point. And at this moment, when you're dealing with the A list, because we'll be identifying areas in terms of the rules and rules that you have outlined, Mr. Njikela, to seek permission for consideration of the issues that are now new and arising from the amendment bill. And I think with fairness, so that we're able to accurately deal with this A list and complete this A list without any other issues that may arise in terms of the challenging this process. But I think guided by the Constitution and the rules of the House, we need to consider the identify areas that we have issues we have raised. We're noting that also deliberation is still going to be engaged at the level of the NCOP. And I fully agree with you that we can't shift the issues that the NA has to deal with the portfolio committee. So I think that is a process which the committee need to carry. Secondly, is that we need to determine the public written submissions with a shorter time so that we allow the committee to deliberate on those issues. I think it's correct that these areas that we are raising, decisions have already been catered. I think it's already been taken. We need to consult our public in terms of those decisions that have been catered on the new amendment on the amendment bill. So I think we're going to call members to comment on that, and then we'll consider for a decision so that the process of seeking permission from the NA and the adverts to be consolidated and come back to the committee for a final consideration. Thank you. Let me start with the Honorable Pillay in that manner.
Thank you very much, Chair. Chair, I just have a concern that I want to raise in that, or perhaps let me start off by saying that perhaps we need to be briefed or outlined in terms of the legal procedures and in terms of parliamentary processes. And I've heard Mr. Njikelo saying that this is what we need to be able to do. But I'll tell you where my concern comes from. Chair, we went through an extensive process of public consultation on the draft electoral amendment bill. We presented that to community, to South Africans. They were able to contribute, they were able to give submissions, come to public hearings, etc. And my understanding is that we take all of those submissions and then deliberate and discuss and then reach certain decisions. And in doing so, a lot of what we see in the A list is having dealt with those consultations and inputs. For example, the 3 months waiting period is something that participants or community or stakeholders were saying should not be there. And upon deliberation and having to go through all of that, we reached a point of saying, yes, it should be removed. And so too with other items that may have come up from discussions. That what we have done is taken the different submissions, the different discussions, deliberated and said, but this is what South Africans are saying, and this is what we have put into this A list. And so for me, I'm saying that, you know, there are certain items that does not warrant, in my view, having to sort of move away or digress from what was originally there. And I think perhaps maybe I'm going to be guided by what the legal procedure is in terms of that, because there are many items that, you know, as you went along would have either changed or tweaked, or having looked at how the different submissions were made, we've taken into consideration. And I'm talking about those people who were interested, who came and made their comments known, gave their submissions. And it's kind of like a slap on the wrist of saying to them, you have submitted this, but now we must go back because it's not entirely, you know, what our scope or mandate was. And then I asked myself the question, then what was the purpose of having to run that procedure the way we ran it? But I'm guided. I said, in everything that we do, we avoid any kind of litigation. And perhaps I just need to be praised in terms of what is the procedure. And if is the procedure, Chair, then I support that we have to. We have to call for that comment. We have to allow it on a shorter space of time so that we also must not be unfair to the NCOP. They are going to start a process. They also need time. And bearing in mind that all of this has to be finalized before December, because that's where our extension is. And now that we are entering September, we are almost done with August, we're going into September, I think that we should then take a decision, if we are, that we must then call for comments now and finalize this process. So Chair, my submission would be that if that's the route we have to go in terms of what the legal advice is, then let us go that route, but let's do it quickly so that we also give and allow for the NCOP their time to be able to engage. Thank you, Chair.
Thank you, Honorable Pillay. Honorable Tito. Honorable Ross.
Thank you, Chair, and thank you to the advisors for that input. I think certainly we want this process to be beyond reproach. And I hear what Honorable Pillay is saying about some of the changes that were derived from public inputs. But certainly there are definitely some material changes that we have introduced. And the thing about the NCOP is, my understanding is that they can make technical adjustments, but not substantive adjustments. So I believe it is in our mandate to ensure that any substantive amendments are made here. In my view, from what I've heard here, it needs to go to the National Assembly for the permission to broaden the scope, shortened facilitated public participation, where the onus will be on MPs in areas that don't necessarily have the internet, and that to facilitate that all South Africans understand the changes and have a fair chance to give an input. And then we come back and consider those, Chairperson, and finalize this. So, Chairperson, that is our view, that we should take it back to the National Assembly for permission, and then go to the public participation, deliberate the changes, and then go forward.
Okay, thank you, Honorable Kanyile. She was not in the meeting, and Honorable Mokhale was not in the meeting. Honorable Lekhwase. Honorable Lizel.
Thank you very much, Chair. I'm struggling.
Noted. Yeah, I can hear you. I think you are struggling, Honorable Khwase. Honorable Molekwa. Today we have a problem of the network. Honorable Mudisemta.
Thank you very much, Chair. I think let me also say we do take counsel from the Parliament's legal services. And indeed, if there are significant material changes or additions that we have made in the bill, and it is a requirement, a constitutional requirement, that we must take it back to the public for deliberations, I suppose that's the process we cannot then run away from. I would also want to ask the legal to provide us with an advice that for how long then that process must then take place. I heard him saying that we do not have to conduct public meetings or call for public participation meetings, but we can call for oral submissions. For how long must then that be taken for that oral submissions and be publicized for comments? Being mindful of the limited time that we now have, Chair, I think if that's the process indeed that we need to embark on, we cannot deny it. Let's then continue as being advised. So thank you.
Okay, thanks, members. Mr. Njikela, you'll come in just to comfort the, not comfort, just to provide more procedural clarity on the issues that were raised by Honorable Pillay, and we then determine the issues that Talena has raised, few issues that were raised, so that were fully noting the issues that will go for public written submissions, and then the time frame that we need to do, so that we come back to the issues to consider those issues that were raised by the public. And I think we're going out for these public written submissions informed by the decision we've taken on those amendments. Mr. Njikela?
Thank you, Chairperson. I will deal with the two issues that were raised by members. Honorable Pillay and Honorable Madisa just recently. We have done an assessment of the issues that have been amended in the bill. And I'm sure my colleague Talana will be happy to share that with the Secretariat. just to facilitate the process of how we proceed. But let me start with what Mr. Pillay has raised, and that this is exactly the concern we had. The Constitutional Court in the Sava judgment, I mean, set the test as a materiality test. To what extent does your changes or amendments change the bill that was before the committee? Was it material? So it could be one word, as it was in the Sava judgment, which brings a completely new profession within a regulation of a bill that was originally not under that bill. So that's the materiality test. Unfortunately, there is no threshold for it. It has to be determined on a case-by-case basis. And that's the situation we find ourselves in now, whether the changes that the committee has made are material. And not all of them, Chairperson, are material. That's why we have done an assessment as to what we consider to be material. And of course, there could be differences of opinion on that. Mr. Pillay, for instance, made an example about the cooling off period. The cooling off period was a provision in the bill. The committee decides to take it off completely. Is that material or is that consequential? Our view is that it is material, to the extent that it was in the bill. You are taking it completely, you're not amending it. You're not saying 6 months or 1 month. You are taking it completely off the table. Our view is that's a material. We could differ because there is no threshold, not even Sava sets that threshold. Sava tells us that we must make an assessment on a case-by-case basis. So that's why there will always be the differences. Multiple regions, there was no provision for it. Now the committee has made a decision that independent candidates must be able to contest multiple regions. We already know that there are views that are different from that. And those views may not have been engaged at the time that the bill was published. And now for the first time, the issue of multiple regions is being introduced. Have we allowed public participation in as far as that issue is concerned? These are just examples, Chairperson. Of course, there could be differences, and I accept that. But I think as legal advisors to the committee, it is our job to put these issues on the table. And of course, Chairperson, we are subject to the direction of the committee. But we will be failing in our responsibility if we don't challenge you to consider these issues and make decisions on. So that if in few months' time or in a year's time, there is a challenge, at least we could be able to put forward a concrete defense to those based on the views that the committee has expressed. And I think that is what, as legal advisors, are required to do by the nature of our jobs. It may appear cumbersome, but these things have to be gone through, debated, and decisions made on. But our job is simply to put the issues on the table, which is what we have just done. On the issue that Honorable Modise just raised, Chairperson, there has been a very extensive public participation that has been allowed. And our view is if there has to be another session of that, it must be limited to the amendments that the committee has effected, and only those amendments that are material and significant. Not every consequential amendment, because there are consequential amendments. So it has to be limited to those that are material, which the members of the public may not have anticipated or envisaged at the time that they made input on the bill when it was advertised initially. So that's why we're saying it doesn't have to be a fully fledged public participation process. Is to invite public to comment on the amendments that the committee has effected, which the committee agrees are material. And that does not require a full session of public hearings. We can invite written submissions within 14 days, and the committee then considers those and makes a decision. That is our reading of what SAVA requires of Parliament, that when you make a significant or material change, at least allow the public to comment on that change. And it doesn't have to be fully fledged. It can be shortened as long as you give them proper notice of the change and give them sufficient opportunity to make changes. And in our view, 14 days may be adequate given the timeframes that we have to comply with. And I think one of the honorable members mentioned that we shouldn't compromise the NCOP because it still has to go through its own processes. That's why to us, the issue of shortened timeframes is attractive, because it allows us to be able to allow the NCOP an opportunity to do its own processes and allow public participation to its own structures and processes. So I think that's what I can say, Chairperson, but we will send, and as Telana had already indicated, we have already considered the issues, and we can share that with the Secretariat on what we consider to be material. And of course, a better idea has to give way to another one. So, Chairperson, I will leave it at that, and I think those are the issues that I only have to respond to now.
Okay, Mr. Njikela, thanks very much. Mr. Njikela, I think one of the issues members may, and I think they were trying to raise, I thought they were not specific. Would it be correct to say that these issues which must go to we must request permission from Parliament could have been raised at this time when we've adopted the A list, or could have been raised earlier on in the course of the deliberations? And I suppose if they could have been raised earlier on, at that time we could not have able to request permission because we will not have envisaged what will be the deliberation beyond that time. We've identified those to the time when we're adopting the A list. I'm trying to reconcile so that members are clearer in terms of the process, whether we're waiting for, it is a correct procedure to have waited for the A list to be adopted, then those issues are elevated for us to allow the permission, or to have been avoided to raise them at the earlier point, because there may be many issues that may be coming in that will require us to have a permission, so that we have a comprehensive issues for permission to be granted so that we proceed with it. Is that the essence of the clarity that you're providing?
Yes.
You're breaking, Mr. Njikela. I think it's the.
Can you hear me, Chair?
Yeah, we are better now. I think let me also ground my video. We are better now.
No, I was just saying, Chairperson, if you look at the Rule 286, in my reading, it provides for two things. Where a committee intends to broaden the bill, or where the committee reaches a conclusion that it needs to incorporate other amendments which are not already opened in the bill. So there are two stages. You could have made a decision earlier that you want to broaden the bill. Or after deliberation, which is where we are, the committee could come to a conclusion we will want to effect these amendments. And you can only make that application at that time. That's why we had to wait for the committee to concretely come to a conclusion that it intends to effect these amendments. And then we assess the materiality of those amendments and then determine whether they will require the House to grant permission. So I think that's where we are. So there are two scenarios that in my reading of the rules, that is Rule 286, that there could be a decision up front that we are going to broaden it. Or the committee could deliberate and come to a conclusion that these are the amendments we intend to make. If those amendments go broader than what was already or bring in new issues, then you must seek permission from the House. And I think that is exactly where we are, Chairperson. I can't take it any higher than that.
Okay, and I think.
Thank you, Chairperson.
Yes, I think it's properly captured. I just wanted us to have the same understanding that it may have happened that earlier on the committee could not have in the position to know that there may be other changes, material changes that will be carrying once we've concluded the deliberations and the amendment. But I must reaffirm that there was a caution by our content advisor earlier on that as we're going to adopt the A list, there are certain changes that will be carried and will need a permission to Parliament to consult more on these changes. I think we're clearer now, members. Your inputs have already processed that we need to seek permission on those issues, and clarity has been sufficiently been provided. We'll also, our reading is that we must shorten the written submissions so that we consider those submissions on those specific areas where we've identified, and Telana or Mr. Njikela will circulate those areas that have been raised. Is that our understanding of the process that we must engage on? I think that's our understanding, Mr. Njikela. Any comments, members? Yes. Okay. Mr. Matonzi, can I get Mr. Salmon?
Chair, we will take the advice given and proceed with the report indicating the request for the additional scope, as well as the indication to advertise for further public participation, and then come up with the draft program accordingly and advise the committee by the next meeting, Chair.
Okay, yeah, you are probably confusing the draft program in terms of the schedule of the publications and how we're going to interface with that, because it will impact on our committee program to deliberate on those written submissions. I think that
yes, Chair.
clear. Yes. Mr. Matonzi, or just dealing with administrative part now.
Yeah, okay. No, Chairperson, I agree with what Mr. Jigela said. I've already done a framework of the report, the interim report. I've sent it to Adam, but once Delane gives us those amendments, then we'll insert them there. And I hope if maybe by Tuesday we could be in a position to adopt that interim report, that the one that seeks permission from the House, so that it could be referred to the House, so that immediately after the House grants permission, then we're able to advertise for 2 weeks.
Okay.
Okay.
Members, is that sufficient in the understanding of the process? I think other members are not here. Let me get Honorable Pillay, Honorable Inton Ross, Honorable Lokhwase, and
Chair, thank you. No, I fully support and concur. We must proceed. Thank you.
Honorable Tito. Honorable Ross. Thank you.
Thank you, Chair. I agree.
Honorable Lokhwase.
Agree, Chair.
Honorable Modise.
I concur. Let's proceed, Chair.
Okay, thanks very much. Commissioner Mieta, is there any other matter you want to raise? Okay, CEO Mamabulo, or the Commissioner
Chair,
Masuku?
sorry, Chair, I was struggling. There are no matters from us.
Okay, thank you. I think that will stand off this item in that process. Will be carried then on Tuesday. We'll then deal with the adoption of the interim report and seek for permission on other issues that we must deal with. Mr. Matonzi, is there any announcement?
Yes, Chairperson. The announcement is that there is the committees on minerals and energy and police. With the incident that happened in Krugersdorp with the Zamazamas, they've undertook a trip there. We're not able to go there as a portfolio committee on Home Affairs because of short notice that were given. And now the Mineral and Energy Committee has done a schedule and invited the chairperson and the whip for tomorrow at 3 o'clock for an oversight that will be conducted over weekends. So we'll give details next week once we have attended the meeting tomorrow. Then the plan is to start with the oversight starting from next weekend. That will be the 3rd and the 4th, every weekend until I think the 15th and the 16th of October. But we'll give the details on Tuesday at the meeting, once we've attended the meeting at 3 tomorrow with the other chairperson of the committee. That's all, Chairperson, from my side.
Okay, thanks very much, Mr. Matonzi. We'll then get that detailed report on Tuesday on the process of the joint oversight. Thanks very much. Thanks, honorable members. Thanks, the Parliamentary Legal Service, State Law Advisor, and the IEC Commissioner and your executive for having considered for this special committee meeting to adopt the A list and also consider for permission that we must carry to the National Assembly to deal with the issues that they were resolved on, so that the community comment on the issues and come back and deliberate. Thanks very much, and our meeting stand adjourned.
Thank you, Chair.